Good morning, Ms. O'Brien.
Good morning, Your Honors. Leslie O'Brien for Zeno Williams. May it please the Court. As the Court knows, Ms. Williams was convicted of first-degree murder under the theory of joint venture in 2005. Her first argument is that evidence that was seized without a warrant was used against her unlawfully at her trial. The argument was not raised by trial counsel, and the defendant recognizes that the Court will consider it under the substantial likelihood standard, but suggests that even under that standard, she's entitled to relief because of the seriousness of the error.
Why didn't her mother's consent to search of the basement encompass the letter?
Well, it's, I suppose as the Commonwealth has correctly noted, the defendant first has to get over the hurdle of showing that she had a reasonable expectation of privacy in that basement apartment that was owned by the mother. So I'm asking the Court to consider a two-part analysis regarding that, and that is first whether Ms. Williams had a reasonable expectation of privacy in the basement apartment itself.
How can you call it a basement apartment? It's really a storage basement in which she just put a mattress or something.
Well, the way it was described by the officer at trial, Your Honor, he said that he went into, I actually wrote down the quote, it's from, I believe, page 191 of Volume 4. In the cellar, it's a common area where there's storage, and there's a back room to the left in the back. And the officers described that they saw a mattress and personal effects as if somebody was living there. So he's describing it at trial as a room.
Well, was she a tenant?
She was not a tenant, Your Honor. She was staying.
Had she been given permission to stay there?
She didn't have explicit permission to stay
How
there.
did she have an expectation of privacy then?
Well, there are actually, as far as an expectation of privacy in the room itself, I'm asking the Court to consider that the sisters, her sisters, who apparently had some authority over the apartment building themselves, they were there to collect rent. And I should say, parenthetically, I'm relying on a police report that's attached to my motion for a new trial. Because I'm taking the liberty of doing that because the trial judge did also in her findings and rulings. But the sisters had the authority to go there and collect rent and check on the building. And they knew that she was there on the 19th, but the police were not called until the 20th. So she was allowed to remain there at least for one night, overnight.
Did the sisters own the building?
The sisters did not own the building, but I'm suggesting that...
well, if the police had gotten consent from the sisters, you would be arguing, I assume, that consent wasn't sufficient because...
I am, because I'm
okay,
arguing...
No, I'm saying if they had gotten consent from the sisters. So what does it have anything to do with anything that the sisters went and collected rent and they didn't own it? They couldn't give somebody permission to go and search.
Well, the point I'm making there is that the sisters apparently had some authority over the building. They had some authority to eject Ms. Williams. They made a decision not to do that. The bottom line is that what I'm saying is that her position was closer to a guest, and I realize not exactly a guest where she didn't have explicit permission, but it's closer to that of a guest than a trespasser, as the trial judge characterized her, as a trespasser or a squatter. She was a family member in a building where she had stayed before. Her presence was at least being permitted for the one day by the family members. They didn't call the Medford police to have her thrown out as a trespasser. What they did eventually was to contact the officers who were investigating the murder to allow them to continue investigating the murder, and which was what they did, of course. But
so who called the police?
The mother called the police, is my understanding.
And she called the police when what? When she had a reason to believe that her daughter, for whom there was a arrest warrant out for murder, was now in the basement of one of the buildings?
That is my understanding of the evidence, that she called at that point, that she wasn't ejecting her as a trespasser, but was turning her in on a warrant.
And what was found in this search of this room that was so important to the case?
There were a number of things that were found, but what I have focused on, I had asked for an evidentiary hearing, and the record is unclear regarding what would have been in a container. And I felt that, particularly in view of the judge's findings, I was restricted in my argument to items that would have been in containers, given the third-party consent of the mother. So what was important to the case was the contents of a letter that was obviously, by looking at the letter, a sealed letter. And I've asked that be made available to the court, and I've been told that it will be made available to the court. The letter was obviously sealed, and the letter contradicts Ms. Williams' trial testimony very significantly in that...
I'm so curious about that because at least in the briefs, I'm dying for an explanation of what was in the letter, and there's nothing in the briefs at all about what it is.
The letter is there, Your Honor.
The briefs, it's not discussed in the briefs in any detail, just that it differed. Was it used in her cross-examination? Did she testify?
Was it used in cross-examination? She did testify.
Yeah.
She did testify.
Was she cross-examined with the letter saying this is
I don't
inconsistent with your
recall
story?
it being used in cross-examination, but it was there before the jury. It contradicted her testimony that
Was it even mentioned in closing argument? I don't think so.
I don't recall it being mentioned in closing argument.
So
But,
it couldn't have been that great.
well, Your Honor, the trial judge certainly recognized the impact because in her findings and rulings, she said that the primary purpose of the letter was to damage Zeno Williams' credibility. And I'd suggest that the jurors having that letter in front of them in the jury room very likely had that effect. Ms. Williams' defense was greatly dependent on her credibility. And that letter should not have been before the jury because it was unlawfully seized.
May I just,
No, go ahead.
at least in your sister's brief regarding closed containers, she says, during the hearing, the judge questioned whether any papers were in a container and noted that the defendant should know how she stored her papers. The defendant made no such claim at the time. Now,
Yes.
you just told us that the papers were in a stored container.
The papers were...
Was that argued to the judge?
It was not argued at the time of that hearing, and the reason why is explained in the motion for reconsideration and my affidavit. I had a great deal of trouble getting access to the physical evidence in this case, and I did make what I think anyone would consider reasonable efforts, but I didn't have access to the actual exhibits until after that non-evidentiary hearing. And I did, after that point, submit an affidavit from Ms. Williams. Now,
the judge have to accept the affidavit?
She did not have to accept it, but she did accept it. She permitted me to file late, and that is I don't know if it's clearly said in the docket entries, but the judge did me the courtesy of clarifying, issuing clarification of her rulings, where she did permit me to file late.
Now, the judge made a finding, I believe, that the record is devoid of anything to indicate that the defendant's belongings were in any closed container.
Yes.
Because the letter was introduced in an envelope that clearly had been sealed and was then torn open. Was there evidence as to when it was torn open?
There was not evidence as to when it was torn open. Again, my request for an evidentiary hearing was denied. However, I'd submit to the court that the only reasonable inference is that it was torn open by the police, because otherwise, the other possible scenarios are that Ms. Williams sealed it and then reopened it, or the police sealed it and reopened it. And I'd suggest that neither of those scenarios make sense.
There are two handwritten letters in the appendix, one on page 96 and one on page 98. Now, one of them is addressed to the district attorney, and the other one looks more like a diary entry.
Yes, there were some pages from a diary. It's only the letter that I'm referring to.
Is the letter, are these one of these two letters that was found in the container?
I'm actually blanking on where the diary was found, but the letter was in the letter was in a sealed envelope. By the appearance of the envelope, the letter was in a sealed envelope.
But it seems that page 98 is the letter, because it says to District Attorney William R. Keating, and it talks about evidence. But and Jamal's blood is in the rug, but if she won't tell you, I will. need me, I'm at home and I'm not pregnant, I don't know how much this helps, but if this is the letter, I don't even see that it's too big a deal, but it was interesting that the letter is addressed to the district attorney and was opened by his agent, so what do you say as to that?
But the letter certainly hadn't been mailed. It was still among Ms. Williams' private property. There was no indication that she had made a decision to mail it or deliver it to the district attorney.
Okay, is that the letter that's in the appendix, or you don't know?
It is the letter. That is the
Page
letter. And I realize there's an additional layer to this analysis, and that's whether, if I could backtrack just a little bit.
Excuse me, did your client admit that she saw the body, that she was she was there involuntarily with her?
She admitted that was her testimony and that was her statement to the police, but in the letter implies something quite different. The letter implies that there was another suspect, possibly the victim's wife.
But why is the letter, I'm repeating Justice Cordy's question, why is the letter so important? I mean, what does it say?
For exactly that reason.
What?
It implies that the victim was killed by his jealous wife, where at trial and in her statement to the police, the defendant stated that she was there in the apartment at the time that the victim was killed and clearly pointed the finger at the co-defendant, Haith. So that's the importance of the letter. And again, the trial judge certainly seemed to recognize that this was, that the primary purpose of the letter was to damage Ms. Williams' credibility, which was the center of her defense. In regard to the
well, let me just stop you 1 minute. If we should conclude that there was no reasonable expectation of privacy in that basement area, whatever one calls it, then that would be the end of this argument. Am I right?
No, Your Honor. That's actually what I am beginning to get to. That even if the court did not find specifically that there's a reasonable expectation of privacy in that basement apartment, there was nevertheless, in the circumstances of this case, a reasonable expectation of privacy in the sealed envelope. And in that, I'm relying, and I'm asking the court to give consideration to the Connecticut court's decision in State v. Mooney, which I have cited. It's a very extensive and detailed analysis of a similar question where a homeless man had made his home under a bridge and had some of his property in a closed backpack and a closed cardboard box. And the Connecticut court concluded that those containers, even though he was a trespasser in a public place, he had taken care to shield his property from public view to the extent that he could, and they recognized a reasonable expectation of privacy in the interior of the containers.
Containers left on a public way, underneath a public bridge? Underneath
a public bridge, somewhat out of public view. But it is a very careful and detailed analysis, and I am asking the court to consider it. I'd suggest that it's helpful in these circumstances. And that court, Mooney, cites a Supreme Court case, Jacobson, where the Supreme Court held letters and other sealed packages are in the general class of effects in which the public at large has a legitimate expectation of privacy. Warrantless searches of such effects are presumptively unreasonable. That's on page 157 of the Mooney case, contains that quotation. So I'm suggesting that
This is a quotation from Mooney, not Mooney quoting something else, am I
It's
right?
Mooney quoting the Supreme Court in Jacobson.
United States Supreme Court.
The United States Supreme Court in Jacobson. So that it suggests that the question then becomes whether the mother's consent to a search of the basement could trump Ms. Williams' reasonable expectation of privacy, either in the room or if she's considered a trespasser in the room. Nevertheless, could it trump her reasonable expectation of privacy in a sealed letter? And for that, I could not find, and I don't believe there is direct authority from this court. So I looked to the circuit courts and also back to Connecticut. Now, the circuit courts, both including the First Circuit, the Ninth Circuit, and the 10th Circuit, have looked to Florida v. Zeno, the Supreme Court case, that looks to whether it was objectively reasonable for the police to conclude that consent was valid as to a particular container. And although Jimeno is not a third-party consent case, the circuit courts have applied it and have concluded that where it's apparent that third-party consent, where it's not objectively reasonable for police to believe that third-party consent extends to a particular container belonging to another person, the police require a warrant. So I'm asking the court to look to that parallel authority. And there are a number of cases, as I've said, that reach that same conclusion.
When you quote the United States Supreme Court, the quote that
That's
you say
from-
Mooney quoted, was it in Robbins versus California or in Jacobson?
It's in Jacobson. It's in the case concerning,
Do you cite Jacobson in your brief?
I did not, and that's why I'm realizing that I'm citing the quotation from Mooney.
Okay.
In any case, the circuits that have considered this have been consistent in finding that it's not objectively reasonable for police to believe that that third-party consent is effective as to closed containers that apparently belong to a third person. And I'm relying on the First Circuit in United States versus Infante Ruiz, where the police pulled over a rental car to arrest Infante Ruiz on a warrant. They requested permission of the driver of the rental car to look in the trunk, and the court held that was not, the driver gave his permission. The court held that was not sufficient to allow the police to open an unlocked briefcase belonging to Infante Ruiz, because it was not objectively reasonable for the police to believe that the third-party consent applied. The 10th Circuit applied the same type of reasoning in United States versus Salinas Cano, where they found that the girlfriend of the defendant, who owned the apartment, was the sole renter of the apartment, did not have the authority to consent to the search of an unlocked suitcase the defendant kept at her apartment, where he slept on occasion. So unless there are other questions, I will rest on my brief.
I just have a question, I think, about your other claim about
Yes, Your Honor.
about the battered woman's defense. What records? Why would the records of Haith's conviction of domestic abuse add to the defense when the defendant is claiming that she had no part in the killing?
Well, an important part of her defense was to explain why she had fled with Jamal Haith. And her claim there was that she fled with him because she was in fear of him. Now there was,
Okay, so it's only to explain her actions afterwards.
Exactly.
Okay, and to that extent, though, wasn't there evidence that Haith had been convicted of domestic assault and battery anyway?
There was a reference, I believe, by a police officer regarding one incident, but in order to corroborate Ms. Williams, my argument is that there was available evidence to show that this was not a one-time, a matter of one incident of abuse, that there was a pattern of abuse. So there was evidence available to the defense that there was actually a pattern of abuse which would be consistent with the doctor's testimony on battered women's syndrome, and that testimony was not placed before the jury. And again, the defense in this case depended almost entirely on Ms. Williams' credibility, so that corroboration was critical to her case.
Just let me go back to the container. What kind of a container was it? Was it like a candy jar or a canister?
Well,
or does that matter?
What I was able to prove without an evidentiary hearing, which I which I did urge the court to grant me, but without the benefit of an evidentiary hearing, what I was able to show was that this was in a sealed envelope.
No.
No.
The envelope was a container.
The envelope was a
Envelope.
But the
container.
envelope was the container, and
But
that
what
the-
kind of a container was it? You don't know?
I'm actually referring to the envelope as a container. There is additional information on the,
Are you making a two-tiered argument that the sealed envelope was in a closed container?
no, that the
The
sealed
sealed
envelope.
envelope is the closed container?
Yes,
Okay.
there was information about that in an affidavit, but it's not clear that the judge considered the defendant's affidavit, so, and for that reason, I haven't relied on it.
Thank you, Ms. Uberlein.
Thank you, Your Honors.
Ms. Alford?
Good morning, Your Honors. There was no substantial likelihood of a miscarriage of justice from counsel's failure to specifically claim in his motion to suppress that there was some special standing as to the letter. First, the defendant doesn't have standing to raise the constitutionality of a search and a rental property of which she had no interest and no right to be there. This isn't a...
Ms. Alford, how do you address the defendant's view that we should view this more like a guest than as a squatter or trespasser?
A guest implies some affirmative action by the host. If this court looks at
You think
Minnesota...
that not evicting her was some affirmative action?
Certainly not in this case, where I believe the record suggests it was a period of 24 hours or less. If you look at the record, Record Appendix 93 of the police report cited by my sister, it was the sister who called the Stoughton Police Department. The evidence would suggest that the sisters went over, they saw clothing. They never saw the defendant. The defendant testified, or there was evidence in the record, the defendant didn't call the family when she returned to Boston as a fugitive. Somewhere in the 24-hour period of time, the mother was informed. The following day, the sister called the detective. The detective went over. The mother signed a consent form. That a period of 24 hours of figuring out what to do doesn't imply that you are sharing your reasonable expectation of privacy, or any expectation of privacy that they may have had in that property with the defendant, who had not even let them know that she had returned to Massachusetts.
How did the mattress get down into the basement?
There's nothing in the record to suggest that.
Are you saying that the evidence indicates that the defendant called her family, and within 24 hours of that, the sisters had called the police?
No, I am suggesting the defendant never called the family.
The defendant never called her
That
family.
they-
She didn't call.
that-
Okay.
That the
I
evidence
misunderstood you. That's fine. So you're saying that within 24 hours of the family learning that she was in the basement one way or the other, somebody learning that someone was in the basement, they called the police about it.
right, the next
So
day.
that's no affirmative action by anybody in the family to let her stay.
No affirmative action. I believe, I don't know if, I may have misspoke that 24 hours in there, but it was that the evening or the day of the 19th, the sisters went over there, they discovered clothing only. The next day, I believe in the afternoon, they called over and said, we've seen some clothing, we haven't seen the defendant. The police said, can we go check for her? The mother said yes, and signed the consent form explicitly allowing the police to take any letters that they found, and that is in my supplemental appendix. The defendant had even if the defendant had standing to challenge this search, she had no reasonable expectation of privacy here. First of all, this was a common basement. Even tenants who lived there would have had only a very limited expectation of privacy. She was a trespasser. She didn't inform the family that she had come. There was no affirmative action that the family wanted her there. She was staying there as a fugitive. One could suggest that she didn't want anybody to know that she was there because she knew, and there was, I believe, her own testimony that she knew the police was looking for her.
What do you say about the letter, the sealed letter? did she have a reason, why didn't she have a reasonable expectation of privacy in the envelope?
First of all, the Commonwealth contests that the letter was sealed. There is no evidence how the officers found it. I would suggest on looking at the letter, it's not clear how it was sealed. If it was, the letter does appear to be torn. I would also suggest the letter could have been sealed after the police found it. It's not clear that the letter was sealed for mailing, I would suggest, but certainly this court could look at the letter.
You have the envelope?
Yes. That there is an envelope. It's addressed to D.A. Keating, and there is a letter. And it was in Exhibit 76.
And it was or was not sealed when the police found it?
The record refers to this as a letter.
Have you seen the letter?
Yes.
Was saliva applied to it, and was the back of it sealed, or was it opened with a letter opener type device or a finger or something like that?
This is where it becomes unclear, and this is why it's the defendant's burden to show that the Commonwealth could not have shown that this was a reasonable search if it was a search. This wasn't raised at the motion for new trial.
Had the letter ever been sealed with saliva?
It appears to be stuck in a couple of places. I don't know if that's saliva, pressure.
Has the envelope been opened by somebody lifting up the flap, or has the envelope been opened by somebody breaking one of the edges?
The envelope is torn in almost a diagonal spot from the flap. My memory is like one part of it's stuck and one part of it's not. It doesn't appear that a letter opener or a finger was used, but I'm speculating about things that should have been raised in the original.
In any event, we will have the envelope and we can look at it.
Absolutely, Your
it's
Honor.
in evidence.
It's Exhibit 76.
Anyway, without something in the record, how could we tell even by looking at the envelope now whether it might not have been put back in and out by jurors and sealed? I mean, it would be totally speculative at this point what condition it was in when the police found it, wouldn't it?
Absolutely, Your Honor, and this is why I am.
Was that an issue at the hearing?
It wasn't, and the Commonwealth.
Was or it wasn't?
The envelope wasn't specifically mentioned, the status of the envelope, and the Commonwealth has moved to supplement the record with the transcript of that hearing because Judge Fabricant, who was the trial judge, who had a memory of how things went at trial, specifically questioned...
Ms. Alford, you don't need to supplement the record because in a murder one case, we look at everything. It would be helpful if you provided us with a copy of the transcript, but is it on file in the court?
It is, Your
We
Honor.
get everything.
Oh.
But it would be helpful if you send it up in any case.
It is.
Did the defendant testify at the hearing on the motion to suppress that she had sealed the envelope?
She didn't testify at all. And to the extent that my sister says there was some difficulty with the exhibits, I note that I submitted a counter affidavit on that point as to her motion for reconsideration. She did not move to continue the hearing or ask to look at the exhibits before the hearing. And then the defendant never submits Judge Fabricant specifically notes that the defendant was in the best position to say if her belongings were in a container or not. And at this point, the defendant was making a broader argument that there may have been some container besides the letter. The focus on the letter was a later argument after it was found that these items were that the motion judge found that these items were not in a container. The defendant's affidavit doesn't come after the hearing. Even if you were to accept that there was some issue with the exhibits, the defendant had the opportunity to look at them the day of the hearing, after the hearing. There's no affidavit filed until the motion judge denies the motion for a new trial. Under Commonwealth v. Snell, the judge was clearly entitled to reject this untimely and self-serving affidavit.
Let me ask you this. Do we reach the question of whether the letter was in a closed container. I mean, do we even reach that unless we adopt the position taken, I gather, only by the Supreme Court of Connecticut, that letters in a place in which you have no reasonable expectation of privacy, if they're in an envelope, they're closed containers? Maybe I'm not asking my question very well.
If you have no reasonable expectation of privacy in a room, do you have a reasonable expectation of privacy in a sealed letter, let's assume it's sealed,
That's right.
that is in that room?
Not in this circumstance, because this letter was left out where anybody could find it.
No. The letter is left out, just as Cowan's question presumes or assumes for the hypothetical that it was sealed. So this,
Okay.
you've got, let's say, a trespasser, so that the lowest rights to the protected rights to the space, letter left on a plain view surface, but letter is sealed.
Not in this instance, because it was addressed to D.A. Keating. She had no reasonable it's clear.
No, my question is, forget how it's addressed. Is there a reasonable expectation of privacy in a sealed letter, in an unaddressed sealed letter, unaddressed sealed letter, in a place in which a person has no reasonable expectation of privacy?
Not in this instance for two reasons. One, anybody could have taken that letter and looked at it. It wasn't
Another
in the mail.
tenant could have come down and taken the letter.
Another tenant, the sisters, the mother. It was an unlocked basement. Somebody could have wandered in. Second, and I do cite the cases of this in my brief, because of the way it was addressed, the contents of the letter were transparent. This is a case, I think I cite.
I don't follow you because of the way it was, what was written on the envelope, the contents of the letter were
Transparent.
You mean relevant to the investigation?
Right. She wasn't trying to hide the contents of the letter from other people. And I would point to State versus Myers.
An invitation to open the letter.
Yes.
Invitation for the DA to open the letter.
Exactly. State versus Myers, and I also cite, I believe, a circuit case which talks about a safe deposit box envelope, where it was marked on the outside of what it was. It was unremarkable then that the police took the safe deposit key out of the envelope and used it. There can be no reasonable expectation of privacy here where she advertised the contents, even if you were to reach the part that that this letter has some special significance. And to address State versus Mooney,
Was the envelope also addressed to the DA?
yes,
yes.
yes, it
It
was.
said D.A. Keating.
District
Didn't it
Attorney
say D.A. Keating? And then inside it said to District Attorney William A.
envelope.
Keating.
But
The
The
letter
letter
said,
was
I'm
addressed
looking
to
at
the
the letter.
And the envelope also was?
yes,
So at least D.A. Keating could open it.
Well, if she wanted to mail it.
but she knew that the police were looking for her. She left this in a place where she had no reasonable expectation of privacy, knowing that the police were looking for her. It's unremarkable that this would find its way to the district attorney.
How do we know she knew the police were looking for her?
I believe it's in her testimony at trial that when she came back to South Station, she had looked at a newspaper.
No, but at the motion to suppress hearing, we can only consider the testimony that was before the judge then.
Well, I would suggest that because she's impugning her own counsel's behavior or actions, it's certainly reasonable to impute that she would have told him that the police were looking for her. I think it's certainly reasonable, seeing if counsel was ineffective, if there was a substantial likelihood of miscarriage of justice, that it's certainly reasonable to impute her knowledge to counsel's behavior.
I mean, the point is, at the motion to suppress hearing, although there was a motion to suppress hearing and dealt with some of these issues, it didn't focus in on this letter and this argument about the privacy of the letter.
It did not.
Right. And so this is raised in a motion for a new trial after the trial's over.
The motion to suppress judge, who was not the trial judge, did find that Ms. Williams consented and had the authority to consent to a search of the basement. And now, at the motion for new trial, the letter wasn't specifically focused on. It was only after, on appeal, it's been focused solely to look at the letter. And what the Commonwealth would suggest was that there's no substantial likelihood of a miscarriage of justice here because the letter wasn't important. It was introduced without incident. It was not mentioned in closing. The Commonwealth did mention that envelopes were found in the basement.
If it wasn't important, why was it offered?
Because it was found in the basement. It did, in fact...
No, you don't have to introduce in evidence everything that was found. I mean,
If they found a hamburger in the basement, they wouldn't have introduced that.
Well, that's correct, Your Honor. But I certainly don't think it had any significant importance. It did tie her to the crime. I'm not suggesting it wasn't relevant. However, if you look at the prosecutor's closing argument, what he focused on was this wallet that was found at South Station. It had checks in it that the jury could infer that the defendant had written. He did mention the envelopes, not the content of the letter, but that there were envelopes found in the basement that matched the envelopes in her purse. It was relevant that
in other words, that was to tie her to the place.
Yes. But the content of the letter, the point that my sister specifically mentions that it impeached her in some way, one, it was not something that the Commonwealth used to make that point, and two, there was abundant other evidence, including her statement to the police that night that her name was Alexis Consuela, that she was a remedial student at Tufts University, statements that were clearly untrue, made that same point. It was cumulative to that point. And just to address State versus Mooney, that was a case that I would suggest was unique, that the state of Connecticut found it was a close case. They found that the defendant had made this place his home, had secluded these things, facts which are not here. The defendant here was a fugitive. Her presence was wrongful, and that these were left about. There's no evidence that she tried to seclude them from the many people who could have been down in the basement. If there are no further questions?
I do. I'm sorry. I have one question about pages 40 to 41 of your brief. I'm not sure I understand the argument you're making there. You're talking about cross-examination of Dr. Ebert on whether his assessment of the defendant's symptoms was based on what the defendant reported to him, and cross-examination asked whether it is almost impossible to determine if or not the subject of the interview was exaggerating. Dr. Ebert noted this was a difficulty with any diagnosis. This brief cross-examination focused entirely on the defendant's self-reporting of symptoms, not the events that might give rise to these symptoms. Thus, the defendant's contention that cross-examination elicited that the diagnosis depended on the accuracy of the defendant's claim of abuse is not supported by the record. What is this whole argument going toward?
It stems from a Department of Youth Services versus juvenile type argument, that the defendant was arguing that even if the defendant didn't have the ability to introduce those records in Dr. Ebert's direct examination, the prosecutor opened the door to the admission of these records under that line of cases by its cross-examination. And clearly here, the Commonwealth did no such thing, as the Commonwealth didn't contest to Dr. Ebert that there were prior violence, but in fact instead focused on that the symptoms of what Dr. Ebert said that she was experiencing, the medical symptoms, that these were things that came from her. Accordingly, it didn't open the door to bring in Jamal Haif's criminal records.
Okay, so you're saying that the cross-examination focused on the medical symptoms of the defendant, but not on the prior violence?
Correct.
Prior violence of whom?
The prior violence of the defendant.
Okay.
Inflicted on her.
Yes. The defense contention was that the co-defendant who had a severed trial, Jamal Haif, had been convicted of assault and battery. There was a violation of prevention order against the defendant. The prosecutor's cross-examination focused on what this defendant, Zeno Williams, told Dr. Ebert as to her medical as to the symptoms that she was experiencing.
I take it that the conflict was that she was saying she suffered from a battered woman syndrome, correct?
That is what she was contending.
And it was the Commonwealth's position that she did not suffer from that syndrome. Is that correct?
It was the Commonwealth's position that it wasn't relevant. That they did focus that she was not a credible witness to Dr. Ebert, but I think it's important to note two things. One is Dr. Ebert couldn't testify if she had battered woman syndrome before the murder, or if the murder caused the post-traumatic stress disorder / battered woman syndrome. And to the extent that the defendant says that this was relevant to her flight with Hafe, the Commonwealth suggests that the record is clear that she testified she left involuntarily, both to her statement to the police and her statement at trial.
Left involuntarily.
She left
She said
involuntarily.
at the point of a gun, she said.
At one point, and then she tried to get help during these bus trips, and then ultimately enlisted some other people's testimony and fled.
And
So-
the defense is not that she committed the murder while under battered woman syndrome, but that she left. She fled with the murderer because of battered woman syndrome. Isn't that how the defense puts it?
It was murky from the record, but I do believe that you could suggest that that's where the defense was going.
But this was
with
not
that.
consciousness of guilt. Flight is classic consciousness of guilt, and she's saying, I fled. In other words, I ran away, I didn't go to the police, I didn't, because she said that she had, in any case, she was explaining why she disappeared, quote unquote, why she was a fugitive.
You could infer that. That would be a reasonable inference to make.
Thank you, Ms. Orford.
Thank you.